Hi, this is Lisa DeMonte with MyLegal.com. It's Tuesday, December 14th, 2010, and we're here in Washington, D.C. at Dickstein Shapiro with our guest, Deborah Epstein Henry. Debbie is the author of a new book called Law and Reorder, and we've been speaking with Debbie about the reasons why she wrote the book, some of the themes within the book, and now we're going to shift gears a little bit and talk about some of the trends that Debbie's research has brought to light. So Debbie, why don't you start with explaining or sharing with our viewers some of the ways that law firms and clients can work together more effectively to bring about a win-win situation while still utilizing alternative fee arrangements.
Sure, and thank you for having me. With alternative fees, one really important piece of the puzzle is to have increased trust with law firms and clients. And trust is an issue that really has fallen by the wayside over the past 2 years in particular, because increasingly law firms feel that clients may be unfair in terms of the expectations of the fees that they want to be charged, and in turn clients have felt that law firms historically have overcharged. So getting the two parties on the same page in terms of trust is really important. And one way to do that when an alternative fee arrangement is established is for the two parties to regularly connect, at least on a quarterly basis, and assess, okay, is the fee arrangement structured in a fair way? Is either party being penalized, or is this fee arrangement being designed to maximize the predictability that the client needs and also ensure that the law firm is still profitable? So making sure that those alternative fee arrangements are fair is really important. And law firms and clients can do this, particularly if they've worked together historically, because there's a history of dealing. So they know how much work is required in working for a certain client, and they know if they've handled certain types of matters for clients that this is typically what it costs and this is typically how it goes. And so between that history of dealing and history of working together, they can really fairly assess the alternative fee arrangement to make sure it's fair for both parties, and then to quarterly have that check-in is a nice way to make sure that both parties are being satisfied.
Debbie, in your research, have you identified any challenges and fallouts that have occurred as a result of these sweeping changes in the legal profession?
Sure, I would say the biggest fallout has been the junior lawyer. And what's changed over the past few years in particular is that no one wants to pay for the junior lawyer to be trained. So historically, the junior lawyer worked hard at a law firm, and that lawyer's work was being billed to the clients. Well, clients are saying, wait, we no longer want to pay for that. And law firms in turn are saying, we don't want to carry this junior lawyer who the client is not going to pay for. So as a result, these junior lawyers are being hired in fewer numbers. So the junior lawyer is really the one who's suffering the most. But it's superficial to just think it's going to be the junior lawyer in the long run who's going to suffer, because it will ultimately become a pipeline problem for everyone in the profession. It becomes a pipeline problem for the law firm because that law firm is no longer training and grooming that junior lawyer to become the senior leader one day of a firm. But it's also a pipeline problem for the in-house legal department, who historically have plucked those talented junior lawyers who become senior lawyers from the law firm, and then they do great work in-house. So the profession as a whole really has to address the junior lawyer issue and take it more seriously and not have a short-term approach to it. Other challenges that I see in the industry as a result of the downturn in particular are the challenge of assessing value. And I see the challenge of assessing value on a number of fronts. One is the alternative fee arrangement, which we've discussed. With alternative fees, there's a real challenge to assessing the value of the matter, and that's something that clients and law firms are really struggling with, unless it's a routine matter that's much more predictable. In the more complex matters, the idea of assessing value of that matter when the measure is something other than time is really challenging. Another challenge in the value context is assessing the value of a lawyer, because many firms are moving away from a lockstep compensation system and moving towards more of a merit-based evaluation and compensation system. And in doing so, the firms have to evaluate the talent pool on a measure other than time. So once again, developing metrics and assessing value of a lawyer's contribution is very tricky. And also measuring the value of a law firm is a challenge. If we move away from the billable hour model and if we move away from lockstep compensation, the question remains, are we going to continue to value law firms and their profitability based on profits per partner, or can we develop another measure for value? So I see value being a really big and important term in our future in the profession.
So it sounds like we need some kind of report card for the lawyer and the law firm.
We do, and I think the core competency model that many firms have begun to adopt is a move in that direction. It's an attempt to create that, not just a report card, but the metrics to evaluate the skills of a lawyer to give them that report card. And so I think we are moving in that direction, but it will really require much more investment on the law firm front in talent management to fairly implement core competency programs.
Debbie, you mentioned before that the client was the big driver of change in the legal industry these days. Can you give us some examples of those changes that the client is really pushing?
Yes, I think one very big issue for the client is the need for predictability in their legal budgets. So along those lines, what the client is saying is we want to move away from billable hours and we want to move towards alternative fee arrangements, which we've discussed. Another big driver for the clients is saying we want you to use, law firms, to use your talent pool differently. We don't want to pay for the junior lawyer, as I've discussed. But in addition to not paying for the junior lawyer, the client's gotten much more sophisticated and said, wait a minute, all of our matters don't require that high-level legal talent that you've been typically staffing on our matters. Instead, let's parse out our work and let's have high-level attorneys continue to do the high-level work. But let's have non-attorneys or professionals handle some of the work that doesn't require a legal degree. And let's have a different class of lawyers do some of the legal work that doesn't require the same challenge and skill. So clients are getting much more involved in the staffing of matters at law firms and much more demanding in how their matters are staffed. And for firms that really are not receptive to those client demands, clients are increasingly outsourcing their matters, so they're having their work performed by companies based abroad in India and in other locations. Or they're hiring companies that just handle, let's say, the discovery process of the matter, and then they'll have law firms handle the more sophisticated work that follows. So those are some of the examples of what clients are doing, and it's created a real push for firms to rethink their own model.
And how are the law firms responding to the demands of their clients in terms of making sure that they're getting the best value for their dollars?
Sure. So what some firms are doing is being much more receptive, and not just receptive, but actually thinking of innovations and creative problem solving to work towards alternative fee arrangements. So rather than wait even for the client to raise it, some firms are really showing initiative and saying, okay, can we design an alternative fee arrangement that's going to be a win-win here? I also see firms looking at their staffing models much differently. So there's an increased use of non-partnership attorneys and temporary attorneys, and that's in direct response to the client's demands that the work be parsed out and be performed by different levels of attorneys. So some firms are using a, quote, insourcing model where they're trying to separate their staffing internally and have their work tracked with different types of lawyers depending on the demands of the work. And that is something that once firms do that and they have different groups of attorneys internally, they're able to bill out at different rates for the different expertise or the different skills of the different attorneys who are working on the matters. Large firms are also, many of them, moving towards a core competency model, which I referenced before, where they're moving away from an automatic lockstep compensation and instead looking at core competencies and a merit-based system where lawyers are evaluated based on their competencies achieved, in other words, their skills achieved, as opposed to it just being automatic that lawyers are promoted annually because years have passed. So in doing that, firms are implementing more of a standardized metric for evaluating their lawyers when they graduate through each level of progression.
Debbie, when we come back, we're going to take one final break here. And in our last segment, we're going to be talking about managing the talent pool.